Good afternoon, Council. This is Judge Silverstein. We're here in Lincoln Power, 2110382. Turn it over to Debtors Council. I cannot hear.
Caroline, we can't hear you.
Okay, they can't hear me.
They can't hear.
How about now? Mm-mm. How about
Your
now?
Honor, not Debtors Council, but can you hear me?
I can. Can you hear me?
Okay. Yes.
Okay.
Just want to see if it was a system issue or technical computer issues.
Okay. Thank you. Then we're here in Lincoln Power, case number 2310382 on second day, and I'll turn it over to Debtors Council. Mm-mm.
Something with the conference room that the speaker have to, I have to mute them on their end, so they have to do something on that.
Okay. Well, why don't we get this fixed?
Can you all hear us now?
Yes.
Yeah.
And now we don't have the judge.
Okay, let's try this again. Can you all hear me?
Can y'all hear me? Yes.
Your Honor, this is
I've got an echo now.
Somebody from them, it's not us.
I'm being told it's not us.
If everyone who's not speaking goes on mute, that may help. Caroline, you be the speaker.
Your Honor, it's Caroline Reckler at Latham & Watkins. Can you hear me now?
That's the first time, yes.
Okay, thank you, Your Honor, and apologies for the technical difficulties. For the record, Caroline Reckler of Latham & Watkins, counsel to the debtor. Your Honor, I wanted to start the hearing, first of all, by thanking you and your chambers for accommodating us virtually today. And also thank you for entering all of the orders. I believe there's one remaining item on our docket, and that's the debtor's cash collateral order. Before we get there, I just meant to provide you and everybody else a brief update of what we've been up to for the last 28 days. I think we've made very good use of the time. We've worked tremendously hard with our lenders and with PJM. I previewed at the first day hearing that we were on the precipice of commencing an adversary proceeding to address certain issues we had related to the winners from Elliott penalties. I'm pleased to say that the debtors and PJM have reached a settlement of all of those issues in principle. We are awaiting sign-off from our lenders, but I'm very hopeful that in the coming days we'll know one way or another whether that settlement will go forward, and if so, we would move expeditiously to file a 9019 motion, and if granted, that would obviate the need for the adversary proceeding that we previewed for Your Honor. So that's what we've been up to in large part. The other primary activity that we've been involved with is the sale process. And I hope that by very early next week, you will be filing a bid procedures motion, setting forth our sale timeline and process. The marketing process has already kicked off in earnest. And directionally, we're looking at an auction at the end of June. But the bid procedures motion will set out all of those dates in further detail. But I think we've made a very productive use of the first 28 days of the case. I want to thank Your Honor for the interim orders that you entered and the final versions that were entered today. Your Honor, with that, unless there are any questions, I will turn the virtual lectern over to my colleague, Mr. Nave.
Thank you.
Thank you, Your Honor. I believe the only item left on the agenda is agenda item number 7, now do the cash collateral motion, which can be found at docket number 11. We received a number of informal comments to the final cash collateral motion order from the administrative agents and Macquarie Bank Limited, which is the counterparty under the debtor's heat rate call option and a secured party under the credit documents. We were able to work with those parties to resolve all issues and submit a proposed form of order under certification of counsel, which can be found at docket number 100. Your Honor, I'm happy to walk through the red line attached to the certification of counsel or answer any specific questions you may have on the form of order.
Thank you. I did go through the red line, and the question that I have is on page, I'm looking at the red line, it's on page 4. Well, it's the carryover sentence from page 3, which begins, except as.
Yes, Your Honor. I'm there with you.
Okay, so I'd like to understand what you think remains of the interim order after I've issued the final order.
Yes, Your Honor. I think the intention here is that to the extent if there was anything that displaced the final order or the effectiveness of the final order, that the debtors and the lenders wouldn't be left without any of the commitments in the cash collateral order in effect, and that the interim order, including the stipulations, the provisions around the challenge period, and a number of the other adequate protection provisions that are included in the interim order would still be in place to protect the lenders and control the arrangement of use of cash collateral.
I haven't had to consider anything like that before, but my gut reaction is that's not correct. My gut reaction is that interim orders are just that, they are interim. It was issued without notice to anybody. The reason to do that is to avoid immediate and irreparable harm, not to provide protections that continue on forever, and that we now have a final order, and the final order is what the final order is. So if there's anything different between the interim and the final order prevails. And if something were to happen, I don't know what could happen to the final order other than getting appealed and reversed, but that is unlikely to happen here as I now have a consensual order and no objections. I'm not sure what this sentence does. So I am not inclined to include it in my order.
Understood, Your Honor, and I'll let Mr. Kandel speak for the agent and the lenders. From a debtor perspective, I think we'd be prepared to remove and live without the sentence.
Good afternoon, Your Honor. Peter Kandel with Kirkland Ellis on behalf of Investec. We took, after further review of the order, we are comfortable as well with that being removed and just having everything set forth in the final order.
Okay, thank you. Then with that, if you send me over a clean copy without that sentence, I will enter it as uncontested at this point, and having resolved informal objections that were raised by various parties.
Thank you, Your Honor. We'll get that revised order over to Chambers as soon as possible.
Okay, very well. I think that's all we have for today, correct?
That is correct, Your Honor.
Okay, thank you. I appreciate the update. Keep working on that settlement, and we're adjourned.